The Supreme Court can consider an earlier decision in the face of a more compelling evidence. That was the question that concentrated many minds on Friday when the news broke that Nigeria's apex court had reversed its earlier dismissal of an appeal by GTB Bank against a 2.4 billion judgment given in favor of Innocent Motors Nigeria Limited by the Court of Appeal in Ibadan, Oyo State. Eyebrows were raised for a good reason. On January 14, 2020, a 7-member panel of the Supreme Court led by Justice Tanko Mohammed unanimously annulled the election of Governor Emeka Ihedioha in the March 9, 2019 governorship election and handed Hope Uzodinma victory on a platter of controversy. It was a judgment that confounded the entire nation. Uzodinma, candidate of the All Progressives Congress APC, polled a paltry 96,458 votes in an election. 70 candidates representing various political parties took part to come a distant fourth. Ihedioha polled 273,404 in the same election and was dutifully declared winner by the Independent National Electoral Commission (INEC). 2 years after, many are still scratching their heads trying to come to terms with the verdict. Nigerians agree that the justices are human after all and therefore fallible. That being the case, it was agreed that if their error was pointed out to them, they would retrace their steps and mitigate what had already become an open sore on the country's jurisprudence. So going back to seek a reversal of the befuddling judgment was an attempt to save the Supreme Court from ridicule. And who else was hired to do the job other than the respected Chief Kanu Agabi, a senior advocate of Nigeria (SAN), former Senator, Attorney General and Minister of Justice? Agabi's appeal was straightforward. The Supreme Court erred on many fronts by allowing Uzodinma to wheedle the unwary justice with his self-tabulated results from 388 polling units. Agabi insisted that based on the spurious results disingenuously produced by Uzodinma and curiously accepted by the court, the number of voters in the Igbo governorship election outnumbered the accredited voters, a situation that would ordinarily invalidate an election. Based on that, he contended that the court was misled into giving the judgment and insisted that it was better to correct the error by reviewing the judgment than retaining it for the future. The justices knew they were cornered. The whole world was watching and waiting, and with no other avenue for further gaming the system, they resorted to judicial abracadabra. It was an open sesame, a hocus pocus of the worst who. On March 4, 2020, 7 justices of the Apex Court, again led by CJN Tanko Muhammad, threw out Ihedioha's plea. But unlike the January 14, 2020 ruling, which was unanimous, the verdict was split. The CJN led 5 other members of the panel, Justices Olukayode Ariwola, Sylvester Nguta, Kudirat Kekereekun, Amina Uge and Uwani Abba Aji, to dismiss the application on the grounds that the court decision was final. The judgment read by Ariwola carefully avoided the issue raised by Chief Agabi and became hyperbolic in its interpretation of the powers of the Apex Court. It was an acceptable vola moment. He heard that the Supreme Court lacked the jurisdiction to review its judgment once it is delivered. Generally, by the provision of the rules of this court, it shall not review any judgment once it's delivered by it, save to correct any clerical mistake or some errors arising from any accidental slip of omission, or to vary the judgment or order so as to give effect to its meaning or intention. Justice Ariwola bold. A judgment or order shall not be varied when it correctly represents what the court decided, nor shall the operative and supportive part of it be varied and a different form substituted. He further said, quoting Order 8 Rule 16 of the Supreme Court rules, it is settled law that this court has no power to change or alter its own judgment or sit as an appeal court over its own judgments. It is clear from the tone and the wording of the instant application that what is being sought is asking the court to sit over its own judgment already delivered and executed. That is certain beyond the competence of the court. It is not disputable that the jurisdiction of the court is derived from the Constitution and an act of the National Assembly. There is no constitutional provision for the review of the judgment of the Supreme Court by itself, and therefore, once it delivers its final judgment, the Supreme Court, subject of course to the slip rule principle, it becomes functus officio in respect, therefore, Ariwola further said. That's a long story there. Okay, we know that Justice Agabi was the one who said that posterity will judge. Even recently, that posterity will judge with this judgment. And now, with what happened with this UBA, GTB bank now, so it can reverse itself. Of course, people knew quite right it was not right. But the unfortunate thing there is that a lot of people know that things are not right, but they will keep quiet because we have a learned people. Some of them will not want to involve themselves in it. When people come out and tell you that, oh, Supreme Court governor, this and this and this and that, and there was an error in that. It was a deliberate act. It was a deliberate act, and they just left it like that. They left it like that. Can you imagine? So, but the good thing about it's a lie is that, unlike truth, it is too weak to stand for long. 2 years after the Supreme Court lie has expired and its poetic justice that the court itself declared the obituary, and the chief priest who officiated the requiem is the same Justice Ariwola. In a unanimous judgment on Friday, the Supreme Court reversed its earlier dismissal of an appeal by GTB against a 2.4 billion judgment given in favor of Innocent Motors Nigeria Limited by the Court of Appeal in Ibadan, Oyo State. In the judgment, a 5-man panel led by Ariwola admitted that the Supreme Court can reverse itself and confessed that it erred when, in a ruling on February 27, 2019, it dismissed the appeal marked SC 6/694/2014 filed by GT Bank. In the lead judgment written by Justice Tijani Abubakar but read by Justice Abu Aboki, the panel, which also had John Okoro and Ellen Ogunwumiju as members, held that it was misled by its registry, which failed to promptly bring to the notice of the panel that sat on the case on February 27, 2019, that GT Bank had already filed its appellant brief of arguments. In fact, where do we start from? Do you also know that Supreme Court also gave judgment on Bayelsa governor election on the eve of swearing the elected governor, and gave it to a PDP candidate on the excuse that the deputy governor of elected? Those are two different things. Your response is biased. There is a substance of judgment in the case of Imo, which is contestable, but in the case of Bayelsa and Zamfara, which is pre-election matter, it is well articulated and understood that a pre-election matter has effect on the outcome of the general election. The verdict of the Supreme Court in Bayelsa and Zamfara was straightforward, unlike the Imo case. This is not about political party affiliation. The truth must be said. I think Governor Uzodinma, he knows that he's sitting on the wrong seat with all these things, because since 2 weeks ago, a lot of things have been coming concerning this judgment, that it will haunt the nation in the nearest future. And now, the same people that said that the judgment cannot be upturned, and they are the same people that say they erred, and they are reversing it. The more you look, the less you see in this country. That's it.